I'm a California lawyer. I graduated in 1995 from the University of California at Hastings. By the end of law school, a lot of my classmates were then marching off to the big firms. I always wanted to fight for truth and justice and the underdog, so I went to work for a plaintiff's employment discrimination firm in the city, making $35,000 a year, and fighting the good fight against the man. I did that for a year. That is a very, very tough practice. There were many long overnights being sort of bullied around. Then I had the opportunity to do criminal appeals. One of the Menendez brothers case, there was a team of us working on that appeal. I worked on death penalty appeals, serious murders, and other felonies. And then discovered after about 3 years, I can't stand sitting at home with a pile of transcripts, which is what being an appellate attorney is about. And sort of coincidentally was starting to share office space with a friend, and our landlord had appellate cases. We started doing that for him. He referred friends, and pretty soon we had a law firm in general civil litigation and appeals. I did that until about 2000, and it slowly began really eating away at me. I couldn't stand, for one, the tedium of being a lawyer, because while it sounds exciting to be a litigator, mostly it's mounds and mounds of tedious paperwork, discovery, complaints. And I also got really tired of having so many of my interactions with other human beings be negative. You get a little charge from that sometimes when you're fighting, but I really didn't want to do that anymore. And I really didn't like the fact that so often my clients didn't get anything that they wanted out of the process, even when they won. And so the very last mediation case I represented someone in mediation, and after a year and a half of litigation, we got the big check that we wanted from the three defendants, and she just turned to me and cried and said, "This wasn't what I wanted. I really just wanted them to say I'm sorry." And I walked out of that feeling, I can't do this anymore. You know, this isn't, I love fighting for people, but I hate seeing what it actually does to people. So I quit law for the first time in 2001 or 2002. Thought I would try various things, including selling travel packages to Belize and selling, I love Belize, Belize is great, selling internet marketing plans to lawyers, and ended up in Boston knowing that I didn't want to practice law and be a litigator, but not knowing what I wanted to do. And that is where I came across the group of people that were practicing collaborative law and trying to expand collaborative law, which is currently really only used in divorces, to other practice areas. And while I did anything I could do to just pay the bills, including typing and filing and a few contract appellate projects, I started gathering people across the country together in a series of phone conferences and then on a listserv around this issue of how do you expand collaborative law beyond family law to other areas. And I got sucked back into law practice again because I saw that along with the collaborative law people, and because of my contact with an organization, Renaissance Lawyer Society, which sort of discussed all these different manifestations of a new way to practice, I thought, if I could practice like that, I'd want to practice law, because for some reason I can't let the law thing go, or it's not letting me go. So since then, I'm now back in California, and I'm working for a defense side employment litigation firm, and also counseling employers on how to avoid litigation and comply with the law in the first place, and sort of on a long-term track to participating in this noble but so far not very well paid quest of how do we have a different way to resolve disputes, and whether that's collaborative law as that has developed, or whether it's something that takes a little bit different form. But I do see that I think within a decade we'll see a lot of different ways of practicing in the civil arena, which is sort of where my heart's at, and including employment and employment discrimination. I sort of use the term civil collaborative as this shorthand for all of these attempts to expand collaborative law into other practice areas, which can be general civil litigation, employment, probate, business disputes, all manner of disputes, construction disputes. And I would say I'm probably the person that knows the most in the country about what people have been trying to do in that front. I'm appointed myself collector of that information for some reason because it fascinated me. And really, I would say how it started, collaborative law itself started in around 1990 with Stu Webb. And fairly early on in the late 90s, I believe, a group in Cincinnati got excited about this. They were family lawyers, but there was also civil lawyers, very high-profile people, and they said, oh my Lord, look at what collaborative law has done in family. Wouldn't that be the wonderful cure to all the excesses of the civil litigation system? And particularly areas like employment or medical malpractice, which are not very well served currently. The human beings aspect of it are not very well served. There's a lot of people left out, and money seems to be the overriding factor of who can get any redress in those systems. Then it's shortly thereafter, there were people in Boston, including David Hoffman, who was the past chair of the ADR section of the American Bar Association. And some other people there formed a practice group which was, from its very beginning, both family and civil. Civil sort of broadly encompassing the 590 or 600 other practice areas that you would keep under that umbrella. Then when I showed up in Boston, which was 2003, 2004, I went to a meeting of this collaborative practice group. It's the Massachusetts Collaborative Law Council. They had a business section that had been meeting for 3 or 4 years, trying a lot of things to expand and promote collaborative practice, speaking to business groups, individual lawyers speaking to their clients, so on and so forth. And what they found was that collaborative law itself, as it's defined, has as a requirement disqualification of the attorney from litigation. And as that was currently constructed, it was an extremely hard sell outside of family law. Part of this is the barrier of, I might sell my client on it, but how is the other person going to find another attorney and sign up to this alternative way? And the attorney's going to sign up to it. And this is a problem especially because a lot of bigger law firms are not about to let a case go if it doesn't work in collaborative. And they say, oh, collaborative law sounds great. I'm not signing on to disqualification because I'm not letting my client walk across the street to another law firm. So I would say that encapsulates some of what the Boston group had come up against. It was also a little bit difficult. The collaborative law movement was very grassroots at that time, and they didn't know if there were anybody else trying to expand beyond family law. And that was sort of the question posed to me at one of these meetings is, who else is doing this? Is anybody else being successful? What's the key to success? And so starting in February or March 2004, I started organizing a series of conference calls. Really, it was just spread by word of mouth. People that we knew across the country said, I just sent out an email saying, do you know anybody who's trying to expand collaborative law beyond family? Sent an email to Stu Webb in Minnesota, and he said, no, nobody's doing it here. I got emails back from all sorts of places, and it turned out, just about coincidentally at the same period of time, there were efforts going on in Texas, Seattle primarily, and a practice group in Northern California called the Collaborative Council of the Redwood Empire. And somehow in early 2004, a whole bunch of people were asking that same question because collaborative law had just started to become known. And people who were sort of seeing the civil litigation system as not a very good solution to people problems also saw the promise of this. And so there's a Texas Collaborative Law Council, which is all civil, but it's very closely connected to the family law group and the Redwood Empire group, which was actually looking at probate and trust and estates applications. And then there was a group up in Seattle, Washington State, which was looking at civil, but was mostly looking at employment-based applications.